Welcome back to Radio Entrepreneurs, the On the Record show from O'Brien and Levine. My name is Jeffrey Davis. We've been here all week, and flanked with me every day, all day, is Mark Z from Mark Z Legal Staffing. Mark, have you met any new lawyers this week? You know them all.
Jeff, I didn't know. I'll tell you something. I've met a lot of great litigators and a lot of attorneys, but I have not had the pleasure of meeting them all, particularly our next guest, who's very, very well known in their field.
Well, I mean, we almost had the whole interview before we even turned on the mics. He was so interesting. I hope we get back into the same story. We're going to be talking to Joe Lipchitz of Mintz Levin on commercial litigation, right?
Yep. Thank you very much for having me.
Thanks for coming, Joe.
Joe, talk to us about your practice.
So I am a litigation partner at Mintz Levin and specialize in complex commercial litigation, but also First Amendment and media law work as well.
First Amendment and media law have really become a lot bigger in the last couple of years than probably in the last 20 years. Whenever I'm looking at not only stations, what's going on in the media, just in terms of information that gets out there is truthful or not truthful, there's a lot of issues, obviously, that come from that. And I know you have, in your expertise as far as First Amendment commercial litigation, you've been involved with a lot of that.
Yeah, so for example, I represent the Boston Herald. I've represented other publishers and celebrities on First Amendment issues. But to your point, the First Amendment issues in commercial litigation is beyond the media, and you see it coming up frequently in the popular press. So for example, about the Washington Redskins and whether they can use that name, that trademark name, and there's First Amendment issues flowing out of that. We've also seen a rise in First Amendment litigation and commercial speech in the pharmaceutical space as well.
How is that? How do you see it in pharmaceutical? I sort of understand the Redskins case because that's on TV every 3 months.
Well, it's an interesting issue. So it relates to off-label drug marketing.
Interesting.
So for years, for the last decade or so, the FDA and the Department of Justice have sort of reaped billions of dollars of criminal fines and settlements prosecuting people for off-label drug marketing. And let me just explain what that is for your listeners. When a drug company goes through clinical trials and gets their drug approved for a specific use, the FDA, under the FDACA Act, requires them to only market that drug for the specific use that it was clinically approved for. The tension comes in that doctors can prescribe drugs for any use, consistent with their good medical judgment. So for example, Viagra was a drug that was originally went through clinical studies for chest pain.
Or Rogaine, right?
Exactly. And so you have drug manufacturers, medical device companies that want to market their drugs for other uses other than what they were clinically approved for. And the government has taken the position for years that if they did that, they would be criminally prosecuted under the Act.
Wow.
And that has happened. So several years ago, you had a pharmaceutical rep that was prosecuted in New York federally and convicted for off-label drug marketing. His conviction was reversed by the Second Circuit Court of Appeals because the Second Circuit said, well, wait a minute, government, you would never allege that anything that this individual had said was false. So therefore, because you're criminalizing potentially truthful speech, that's violative of the First Amendment, and they reversed the conviction. And so now if you fast forward to last year, there was a drug company called Amarin Pharmaceuticals, and that they had gotten their drug clinically approved for lowering triglyceride levels at a certain level, gone through clinical studies. The FDA on its own had done a internal study that showed that the drug was quite effective for lowering mid-tier triglyceride levels, and Amarin wanted to market it for that use. And the FDA basically said, if you do that, we're going to prosecute you for off-label marketing. Ameren took the position of, we'll see your threat of a lawsuit and we'll raise you one of our own,
Oof.
and we'll sue you for a preliminary injunction. And so you had a drug company seeking a preliminary injunction against the government, claiming that their threats of prosecution infringed on their First Amendment rights, and the injunction was granted,
Interesting.
which was huge
Wow.
news. Since that time, the court has made the parties engage in settlement talks, and then on March 8th, the parties announced publicly that the FDA and they had reached a settlement where the FDA publicly acknowledged that they couldn't limit truthful, non-misleading speech.